Ashley Heidemann from JD Advising. Before we dive into our video, let me give you some background on our completely free law school prep course. You can find a link below and sign up to access it right away. And if you find this video helpful, please like and subscribe to our channel. As of this taping, we have literally thousands of students enrolled in this free law school prep course. We're also very grateful that students rated this course an average of 4.76 out of 5. This course is posted as a free resource on the Law School Admission Council, or LSAC's website, and was just mentioned last month by U.S. News & World Report and the National Jurist as being a helpful law school resource. It has also been promoted by the National Black Law Students Association, Phi Alpha Delta, and various law schools and undergraduate institutions across the country.
In this lecture, I'll be lecturing on criminal law. The point of this exercise is so that you can practice taking notes. Now, the only real difference between this lecture and what you might actually experience in your law school classroom is that I'm not going to be putting anyone on call. Instead, the focus of this is not on the Socratic method, but rather on your note-taking ability. So let's get started. There are two basic elements of every single criminal offense, the actus reus and the mens rea. Starting with the actus reus, this is a guilty act. What this essentially means is that you have to do something to be criminally liable. This is because our law does not punish thoughts, no matter how evil those thoughts may be. Why? Because we can't always help what we think. The other way to look at this is that the thoughts themselves don't actually cause harm. Further, when we discuss criminal actions or an act, this does not include omissions or a failure to act. We do not typically punish what we call omissions. For instance, you can watch someone drown without helping them. Or if you're walking down the street and you notice that your neighbor's house is on fire and burning down, you don't have to call 911. You don't have to try to assist. There is no law saying that we have to be good Samaritans. But you might be wondering, why not? How long does it really take to call 911? Everyone has a cell phone in their pocket nowadays anyways. How hard is it to throw someone a life-saving device if they're drowning in the water in front of you? Shouldn't we all be required to take these small steps? Because if you think about it, these small steps have such a great effect. Shouldn't we have to do that? The answer is no. We do not have to act for several reasons. The first reason is due to line drawing problems. For instance, who would be liable for a failure to act? Who do we include and call liable, and who do we exclude? How do we make that decision? How can you prove that someone knew the house was on fire or that someone was drowning? How would you know who didn't know? How would you prove who didn't know? The other reason is the bystander effect. This is the idea that the more people that are around, the less likely anyone is to step in and help. No one wants to look dramatic. No one wants to help and maybe make themselves look like a fool or do something wrong. And oftentimes, people make it worse when they step in and try to help. Further, some believe that the more people there are around, the less responsibility any one person feels to take action. The other reason for this is freedom. We've all killed someone by failing to act. For instance, we've all failed to donate money to a charity. And had you donated money, you could have bought someone food or shelter, or ultimately saved them. Additionally, we run into the issue of coordination problems. For instance, if we all see a problem and we all jump in at one time, is that really helping if we're all doing the same thing, getting in each other's ways? Thus, these are some reasons why there is no criminal liability for an omission or a failure to act. Omissions are not generally considered an act for purposes of an actus reus. There is no criminal liability for failure to act unless one of the following exceptions apply. The first is if there's some sort of law or statute that requires you to act. For instance, oftentimes teachers are obligated pursuant to statute to report suspected child abuse. Similarly, medical professionals are usually required to report instances of suspected elder abuse. In the case, in reappeal of O'Boyle, it discussed statutes regarding caregivers and ultimately neglect. And in that case, the statute said a caregiver had a duty not to neglect the person in which they were supposed to be giving care to. But the court never actually made a finding that Sharon O'Boyle was, in fact, the caregiver. That case went out of their way to say they did find neglect, very obvious neglect. The victim of neglect had a broken foot, scrape on her forehead, was dehydrated, and malnourished. But there was never a finding by the lower court that Sharon O'Boyle was, in fact, the caregiver. Thus, there was no liability unless she was required by statute to care for the victim. The next exception is if there's some sort of status or special relationship that requires a person to act. For instance, spouses are required to act on one another's behalf or to help each other. Additionally, if there is a parent and child relationship, parents are obligated to act and try to help or save or give aid to their children. You might be thinking to yourself, why does it not go the opposite way? Why are we not discussing the fact that a child owes a duty to a parent? This is because children don't owe a duty to parents, but parents owe duties to children. This is because parents choose to have children. They give life to a child. A child does not choose to be born. A child does not choose their parents. Further, what if the parents are not good parents? Why should a child then owe a duty to their parents? Additionally, as it relates to the spousal relationship, we pick our spouses. Thus, we should owe them a duty once we enter into that relationship. The third exception is contracts. Now remember what a contract is. We need a bargain for exchange or consideration to have a valid contract. This means you need to give something up to get a benefit, and you can then expect a benefit. When you have a contract, people on both sides of the contract are giving something up to get a benefit. So for example, if you pay $50 to get a shirt from an online retailer, you're giving money to get something, the shirt. That's a bargain for exchange. The retailer is giving up a shirt to get a benefit, payment. Thus, there is consideration. Now, contracts are different than a gift. Gifts are when you receive something nice, but without the expectation that you're going to get something. Or in other words, there is no consideration. You're not giving something up to get a benefit. Whereas with a contract, there is a bargain for exchange. So there is an expectation that you will get a benefit once you give something up. There are two types of contracts, express contracts and implied contracts. Express contracts can be written, which I think a lot of people associate with a more formal contract. But express contracts can also be oral. So for instance, if I say I'll give you $10 to wash my car and you agree, we don't have to put that in writing, as it would still be considered an express contract. Now, an implied contract, on the other hand, is different. There is no statement or formal writing evidencing the agreement. Instead, an implied contract is when we imply or assume that there is a contract by virtue of the parties' actions. So for instance, if you walk into a beauty salon and you don't sign anything about how much money you're going to pay for your services, nor is there any discussion where you promise to pay a certain amount of money for the services. But nonetheless, you sit down, you receive a service, and you're ultimately expected to pay at the end. The conduct implies the fact that there is a contract. We read a case on this point, Davis v. Commonwealth. In that case, the court found an implied contract for the daughter to care for her mother because the daughter was receiving several benefits as a result of her taking care of her mother. For instance, things like food stamps, rent-free living, Social Security benefits. In exchange, the daughter was required to care for her mother. Now, there was no express statement about this agreement, nor was there a formal agreement put in writing, but an agreement was implied by virtue of the parties' conduct. The daughter was getting these benefits, so in exchange for the benefits, she had a duty to take care of her mom. The next exception is when you create the risk of harm. Earlier, we talked about the situation where if you're walking down the street and your neighbor's house is burning down, you don't have an obligation to help. In other words, without other facts, you have not committed a criminal act if you do nothing to intervene or help. Now, the rule changes in the event you cause the harm. If you caused the fire that is burning the house down, now you have an obligation to act reasonably. For example, it would be reasonable to call 911. You wouldn't necessarily need to enter the burning house in an effort to save your neighbor. That would not be expected. Thus, if you cause harm, there is an obligation to act reasonably in response. Our fifth and final exception is the voluntary assistance exception. If you decide to assist someone and you are voluntarily going to render aid to them, then you have a duty to continue to act reasonably. If you fail to act reasonably after you start assisting them and you leave them in a worse position than you found them, then you are liable. For example, if you're driving down the road and you see an awful car accident happen, thus you decide to pull over and help. Once you start rendering aid, you have a duty to act reasonably. If you stop rendering aid and you leave the people in a worse position than you found them, now you are liable. One reason for this rule is once someone intervenes and starts rendering aid, usually others do not jump in to help. Or if there was a crowd, it usually disperses. Thus, we want to make sure once you start giving help, you complete it, as not to leave the victims in a worse position than you found them. All right, so that wraps up the actus reus, or the guilty act. The second requirement for every crime is the mens rea, or guilty mind. You need to have some kind of guilty mind to be found criminally liable. For instance, if you kill someone by accident, let's say you hit a pedestrian walking across the street while you're driving your car. That's very different than an instance where someone is plotting to kill someone by gunning them down or hitting them intentionally with their car or, say, poisoning them. In the latter instances, you're going to be liable for the criminal offense, whereas in the former, where you accidentally hit someone, you will not be guilty because you did not have a guilty mind. That wraps up our criminal law lecture.